When it comes to domestic and cross-border deals, one of the key things to take into consideration when closing off a deal is to assess the corruption risk that could be associated with the target company. Now, taking you a step back, when we talk about mergers and acquisitions, we can have company A that intends to buy company B. In this particular instance, company B becomes the target. Now, as company A goes about buying company B, there are certain risks that could be associated with that particular deal. In this particular video, I will be focusing on assessment of the corruption risk that could be associated with the target company. And as you can see here, we have what we call evaluating the business side of the target. So we have company A intending to buy company B. Company B is the target company, but how do we go about assessing the business risk of that other company that company A intends actually to acquire? Now, as a compliance professional, this is where compliance due diligence and risk assessment comes in, because for you to effectively assess the target company, there are certain key investigative questions that you can expound on to fully understand and assess the corruption risk that could be associated with the target company. And of course, one of the first important key questions to ask yourself is that if this is a cross-border deal, where does the target company do its business? Then you'll be looking at the jurisdiction. Jurisdiction means the country within which that particular company could be located. It could be a bank in Kenya, for example, intending to acquire another bank in Congo. So you have to assess this target in terms of where it does its business. Number two, you'll be thinking about how this particular target does its own businesses, and of course, going a step further to assess with whom does the target do business. In the course of this video, you will be able to understand how to effectively assess corruption risk that could be associated with a target company, because when it comes to mergers and acquisitions, this risk should be fully assessed to the extent that if you do not assess this risk, of course, you may end up buying or acquiring a company that actually has fundamental problems. And those problems, of course, end up becoming your new problems that you've inherited out of this particular merger and acquisition. As you look at a target company to fully do your compliance and due diligence, as well as risk assessment, and of course, in particular, we are assessing the risk of corruption that could be associated with a target company. The simple words to follow are the where, how, and with whom. And as you can see in this particular slide, the where will guide you to assess whether that particular company you want to acquire is in a high-risk jurisdiction. Then you'll be thinking about if it is in a high-risk jurisdiction, how has it been operating? Has the target been giving out donations and gifts? Maybe you can assess the period. Who did it give the gifts to? Because it is through gifts and donations that people are able to move corruption money. And then, of course, you'll be thinking about the how. When it comes to the how, this target company that you're trying to acquire, does it have any government and regulatory touch points? Meaning that there could be licenses, approvals that this particular company has been, of course, paying for. It is through these licensing and approvals and lobbying and, of course, also political contributions, these sort of circumstances create room for corruption to happen. So by just looking at the background history of how licensing was done, how permits were granted, how approvals were conducted, you're able to assess whether this particular target has ever been involved in corruption. Number two, if that particular company has been involved in lobbying, issues of politics, funding, politicians, you can also be able to use that to understand whether the company has made any contributions to political organizations, and if those contributions were done, what was the intended benefit? The other thing to think about is high-risk third parties. The company you're acquiring, it works with third parties. For example, if you are acquiring a supermarket in Congo, that supermarket could have several other stakeholders it works with. These could be suppliers, distributors, and different parties. So amongst those third parties associated with the target company are some of them high-risk third parties. An example here would be government. In most cases, if a company has close association with government, it is important again to assess that relationship, because sometimes there will be some agents or middlemen working in between that company and government, of course, to close deals. So here you'll be thinking about how are these deals awarded? What are the channels used to, of course, create these partnerships and the transactions between the company, the third parties, and the government? So you do a roadmap to understand any third party associated with that target company and assess the risk. If it is government, then you pay keen attention to that to understand the benefits around that relationship. And then, of course, we also have high-risk customers. Again, here, the customer to that target could be government. How are these high-risk customers working together with the target? What is their benefit in terms of that particular relationship? Is there any gifts exchanging? Are there any sort of back deals that could have happened in the past? That can also reveal corruption when it comes to assessing the corruption risk associated with a target company. Then you'll be looking internally within that target company. Are there some sort of compliance and controls associated with the target company? For example, are there certain policies safeguarding against corruption? Do they have a whistleblower policy? How is their legal and compliance department? Has there been any audit in the past 6 months or so to assess the financial health of that particular target company? These controls also expose the corruption risk. Then the last point is to think about when it comes to the board and corporate governance of that particular target. Is there any board member that is a politically exposed person? And a politically exposed person, this is potentially a person working in a high-profile government position. And these could also be the relatives, their children. So you're looking at the board composition. Is there a politically exposed person? You'll be looking at the supply chain of that particular target. Has there been any child labor to that extent? If you're thinking about issues of ESG, environmental sustainability and governance, what has the company done in the past, to protect the environment? And as far as this particular board composition is concerned, is there any sort of conflict of interest? Do board members have a history of corruption? Is there any pending litigation? By litigation could be a court case against that target. Because remember, even the cases against a target company, once you take over, you could end up inheriting all the burden. So as you're asking yourself some of these questions and you're ticking off your findings, you're able to come up with a whole overview, an assessment of the corruption risk associated with a target company. And as you're doing this, you've just identified a single risk, which is the corruption risk, and you've assessed it so that it can inform how you're going to conclude the deal. And this deal could be a domestic deal or even a cross-border deal that involves one company trying to buy another company. And of course, in simple terms, or a more technical word would be a merger happening between two companies, a merger or an acquisition. Before you close any deal, especially when it comes to mergers and acquisitions and cross-border transactions, remember that the corruption risk at face value is not obvious, But as you dig deeper by asking specific questions that actually appear to be very simple, you can end up getting a revelation of many hidden problems tied up in corruption as far as the target company is concerned. And so at all points, it is important to appreciate that compliance and due diligence is not just a cost to an organization, but rather it is a protection layer, because the cost you spend on compliance and due diligence is just a fraction of money that you would actually end up spending if you inherited a company that has immense problems. You'd rather cut off the deal way early than fully committing and inheriting a company that could have been operating based on corruption money. My name is Rogers Gidinji, and as we come to the end of this video, remember to stay tuned to Nairobi Legal Insights for proper understanding of how laws work, simplifying the laws for non-lawyers, and creating legal awareness, because access to information allows people to make the right decisions. Thank you.